Hey, everybody. Happy True Crime Wednesday. Look at this little guy I have on my shoulder. Thanks to a viewer who sent it to me. Her name is Connie. And this adorable little guy, I was trying to do too many things at once. Thank you so much, Connie. He is so cute. And for those of you who don't know, I've been taking beekeeping classes because I've always wanted to keep urban bees. So I've been taking the classes, and I'm hoping to do a little bit of work in the bee yard locally here to sort of get familiar with keeping bees. But I won't be getting my own bees this year. Um, I got a beehive for Christmas, and I got a beekeeping class for my birthday. So I've been doing all of those things, but it's probably just as well that I am not undertaking bees right now because I have a little news to tell you. So, but first of all, I want to welcome everybody. My name is Lori Hellis. I'm a retired criminal attorney and the author of that book up there on the Lori Vallow Chad Daybell case. And have some other projects sort of percolating around in the background um, for new things to undertake. I just want to remind everybody that this is not legal advice. So we are here just for fun and entertainment, and everything I say is my opinion. So, but oh, I also wanted to tell everybody that we're doing a website refresh. You know, back when I got started, I had l- lots of things going on. We had a website for the people who were early readers of my book. We had a Lori Vallow website. I had a Lori Hellis website, and so at one point we had the Good Lori website that was for the book launch. So, my IT expert is in the process of bringing all of those things together into one website at lorihellis.com. And that website then will have a page for both of my books, for some of the other projects that are coming up, as well as a link to Substack. For you all that have been here with me for quite a while, um, you know that I have sort of an on and off newsletter. During the time that I was following the Lori Vallow trial, I did a lot of them, and a lot of them were sort of basic about things like bail and jury selection and a lot of different sort of legal issues, more in depth. So, I am going to resurrect the newsletter, but it's all going to live on Substack. And that they will be available if you get on there and subscribe to my Substack. And it will be free. So, but it is just a place for them to all live. So the archive will be moving to Substack. So, um, so I have some news. As Rosanna Dana used to say, if it's not one thing, it's another. So about 3 weeks ago, I went and got my routine annual mammogram. Y'all can see where this is going. I had had a couple of other times where they had called me back to do more diagnostic work. I'd actually had a biopsy, and always everything had come back just fine. So when they called me and said, "We want to take another look," and they did the diagnostic work, I wasn't so worried about it. But when they did an ultrasound, they said, "Well, you do have a small mass here." So I had a biopsy, and it came back that it is invasive ductal carcinoma. Um, it is very small, found very early. My doctors sort of disagree on whether it is stage 1 or stage 2. Um, so I know that I am joining a very large sorority here. And so I know that you all are no strangers to this and have probably been through this ahead of me. Um, so just kind of, basic information. Tumors are they test them for reactivity to certain uh, hormones or proteins that in, increase the likelihood that they grow. So they test for two hormones, for estrogen and progesterone. But my tumor was positive for both of those. The third thing that they test for is called HER2, and that is a human growth hormone. And if your cancer cells are created with many extra receptors to that human growth hormone, then it can fuel your particular cancer. So it's important to know whether or not your cancer is HER2 negative or positive. So my test came back equivocal, meaning they needed more testing. So we've been waiting for that to come back, and it came back today, and it is negative, which is a good thing. If you have a HER2 positive uh, biopsy, it means that you probably will have to do additional chemotherapy, and it's a much longer and more invasive treatment plan. So it was good news that that was negative. I have an MRI scheduled tomorrow, and then my surgeon will have a little bit more information to make some decisions about surgery. But right now, it looks like what they call a lumpectomy, which is a partial removal of the tissue. It's a partial removal of part of the breast to remove the cancerous tissue, and then about a month's worth of daily radiation. So that's where we are so far. Um, what I know at this point is that I likely will have surgery in mid-April, a couple weeks from now, and then we'll follow it up with radiation and hormone blocking therapy long term, which is pretty typical. So, so here, I mean, it's been a little overwhelming. So that's why I didn't do a live last week. That was the evening that I got the diagnosis, and I just didn't have the mental bandwidth for it. I just couldn't get there. So I appreciate your patience. It's also set me back a little bit in a couple of my projects that I want to get done, including the Granny Files. I am still diligently working on it and had entirely intended to get episodes out before now. However, that's where we're at. So we're still working on it, and that is going to be released on Patreon. So that is all of the news fit to print from my end of the world. But I do have a couple of interesting little things before we get into talking about um, the cases that have been in the news the last couple weeks. So I got this email from a person who said, I found you online, and I need to ask you kind of a strange question, but is the Mark Means who lives in Troy, Missouri, the same Mark Means that was involved in the Lori Vallow case? And the reason she asked was because he had recently written a really scathing um, letter, article, not really sure which, about high school sports. So I looked at the at and she sent me um, this. So I'm just going to share it with you here. And lo and behold, that is him. He is now teaching and is the yearbook advisor at Troy Buchanan High School in Troy, Missouri, which, as I understand it, is um, somewhere outside of St. Louis. It may be a St. Louis suburb. So we've known for a while that he left Idaho. He left Idaho under a little black cloud, frankly. There were several bar complaints pending against him, and he resigned from Idaho bar before they could disbar him. And I know he applied to the Missouri bar, but he was never admitted. So I sort of think that he didn't get admitted because any state bar that you're applying to will only admit you if you are in good standing with any other bar that you belong to. So, not surprising that he did not get admitted to the Missouri bar. So now he talks about in this article that he is a retired um, lawyer, and that's not exactly true. He left the practice of law under a cloud. So it was kind of interesting. I replied to her and said, "Yeah, that's the same guy," and I'm not surprised. However, um, when he says he is a retired lawyer, it's only because he left the practice sort of under a cloud. So, um, but I thought that was a gee whiz. We hadn't heard anything about Mark Means in the most recent future, and I will tell you that his this article that he wrote it has to do with high school sports. Now, my recollection is that he's got children the age of high school to be active in high school sports. And my recollection is that his children were very active in high school sports, that there was a lot on social media about at least one of his daughters being very involved in sports when he was in Idaho. So, this article is about complaining that the public schools have to go up against a private school. And, this is a complaint no matter where you go. If there is a private school in a large urban area, they can draw from the entire county or even the entire state. They can draw students, and there are rules about whether or not they can recruit um, athletes, but um, kids who can sign up from all over the state and all over the county. So it means that it's often um, possible for them to draw students in areas where the public schools wouldn't necessarily be able to concentrate the athletic talent in one place. And so he was complaining about the fact that they always have to play this powerhouse private school, and the private school always wins all the state championships. And this was basketball, I believe. But his his the article was written just as poorly and with just as much hyperbole as all of his Lori Vallow pleadings. So I could definitely, when I looked at it, I thought, yep, that's Mark Means for you. So, um, so if you happen to be in Missouri, he's a high school teacher at Troy Buchanan High School in Troy, Missouri. So, well, pretty big, um, we had some pretty big verdicts this week. Uh, First of all, we had justice for Dee Warner. That case was out of Michigan, and her husband was found guilty. Um, that was really a sad case. Dee disappeared. Her children always believed that Dale was involved in her disappearance and that she was dead. But they couldn't find her body. And a lot of things went into holding him accountable. The first thing that happened was that the family filed a wrongful death suit, and they wanted her declared dead so that they could deal with her estate and they could go after Dale for her wrongful death. In the meantime, the investigation finally turned up her body in an anhydrous ammonia tank on the family farm. They had a large farm, and they did a lot of work with fertilizers, and they used this anhydrous ammonia as part of their fertilizer um, cocktail. And it's very caustic, so people stay away from it. So it wasn't a place that people were going to be looking. They X-rayed the tank and could see the outline of Dee's remains inside. So they opened up the tank. It was indeed her, and he actually had already been arrested for her murder when they found her remains. So if you watch the trial, one of the things that I was really impressed with was their farm and all their associated property had cameras on it. There were a lot of security cameras, and the prosecution did a really good job of being able to piece together a timeline from all those security cameras, and they were really able to sort of give the jury a visual timeline of here's Dale doing this, and here's Dale doing that, and here's Dale doing this. And I think it was really helpful for the jury, and I think it really um, sort of sealed the deal for Dale Warner. I think it really solidified in the jury's mind um, what what had happened. So, so I thought they did a good job. He was found guilty. He has not been sentenced yet. Um, but the big news is Corey Richens, and I'll tell you what, I watched most of the trial. I didn't watch all of it, but I was surprised at how quickly the verdict came back. It was less than 3 hours. Um, and the jury foreman spoke out. I think today was the first day she was talking, and she said there was a lot of there were a lot of people who went into it kind of having a firm idea of what they thought happened. And it was interesting because she said, um, I looked at Corey and I really wanted it not to be true. I wanted it not to be true for her kids. I really wanted it not to be true. But um, the more we heard, the more I knew that it probably was true. So I thought that was really interesting. Um, and I was shocked that, sorry, I was turning off some of those bright lights on my other screen. I was really shocked at how quickly the verdict came back. Um, it seems that the jury had a pretty clear idea of what they believed happened, and they believed that the prosecution's narrative. The prosecution did an excellent job, especially in closing. Their presentation in closing, which was so comprehensive, and they would put up they were talking about the elements of the crime, and they would say, here's the document that proves that, here's the evidence that proves that. They were actually pulling clips out of the streamed uh, the streaming of the trial, because they don't really have transcripts, but they were pulling clips out of the streams from the witnesses' testimony. And I thought they did a really masterful job. You know, I do believe that the defense came into this trial and they had a plan and they had a strategy. I know there are a lot of people who feel like they didn't. But I think they did. And I think that they were trying to make the best with what they had to work with. Now, I want to remind everybody that these lawyers are public defenders. They don't have the staff and the resources that the prosecution has. It's just the reality. Um, the state always has more resources and more money and more people to throw at the case than the defense is ever going to have. So they had the staff that was able to put together that closing argument presentation. And I think that, first of all, I think the defense did a poor job at their closing. And I think that they were not as on top of their game. Now, if you watch the closings, both of the defense attorneys were sick. Both of them have got some sort of cold, flu, whatever, and they were motoring through it. Now, I'm here to tell you, I have been there, because you get into a trial and suddenly you get sick. A lot of it, a lot of it is you are pushing hard to get ready for trial and you're burning the candle at both ends and you're just, really going at it, and it can run you down. And I have been through going to trial while I'm sick, because you get to the eve of trial and you just think, oh man, you know, we're ready. And I I have to just power through. And so I think they were really sick. Um, I notice here one of the comments says Nestor and Lewis have their own firm, not public defenders. I don't think they absolutely are public defenders. So, like a lot of public defenders, like I did, um, public defenders often work on a contract basis with a contract with the state. Um, there are many different ways that public defenders are um, many different like models of how public defenders are put together. So in some states, the state has a state agency and it hires lawyers, and those lawyers are public defenders. That is uncommon. In most states, they contract with attorneys who are practicing out on the out in the wild, and they contract with those attorneys to accept cases at a specific rate for as public defense cases. And then the state also pays for experts and support and those sort of things, but they don't provide that level of support at the same rate as the prosecutors have in their offices, because that's just built in. So I do believe that they were appointed um, and that they were paid by the state. They were appointed and paid by the state. Corey Richens didn't pay them. The reason that Sky Lazaro left in part was because of the financial obligations. So, um, I like I say, I think I was surprised at how quickly the verdict came back. Um, on the last day, when the um, when they were doing closing arguments, the the day before, the judge said, "I'm not reserving any seats in this courtroom for the public." Now, what had been happening was this is a very small courtroom. Unlike most courtrooms where you have, like 2 sections of benches with an aisle in between, this just had 1 section of benches. Very, very small courtroom. So, the way it had been working was there was 1 row for the media, the front row. The second row and third row were for the families, and those alternated back and forth who got the closer row. And then there were 2 rows, there was 5 rows total, um, for the public. However, the judge said there are a lot of people who couldn't be in the courtroom while the trial was going on because of the sequestration order. And so there were other family members who really wanted to be there. So the judge said he was going to bring the media in the front row. You had to have media credentials. And then the second and third row and the fourth and fifth row, they were going to reserve for both families. Um, and as it sure and the judge had sort of made some provisions for swapping that if the trial went into the next day, which it didn't because they came back with a verdict. So, um, I know that Gigi was able to get in, she's a works with law and crime, so I think she was able to get in. Our friend Lauren was also able to get in and was in the front row. The other thing that I found concerning was that very quickly, first of all, Lauren had a live, and Corey's boyfriend, the guy who had testified and been so nervous and so overwrought, um, dropped into her chat. So before long, she was chatting with him offline, and it was kind of sad because on one hand, during her live, she was making fun of him and the text messages that he and Corey had exchanged and laughing and belittling this guy. And then all of a sudden, they're besties. So in sort of um, behavior that is not unexpected, let's put it that way. So, but what I thought was really, and the other thing was that she then put out a live saying that she had met with Corey's family. And even though she had really vilified Corey, made fun of her, um, she was firmly in the she's guilty camp from day one. Um, then, sort of, once again, got familiar with Corey's family. Um, but the interesting thing is that this is sort of serendipity, I guess. The court advocate, the victim's advocate that was the victim advocate in the Lori Vallow trial, um, is now the victim advocate in Utah, in this court. And so obviously she moved from Idaho to Utah. And the other thing that I thought that was really interesting is that Kay Woodcock was there, which made me wonder if Kay maybe has a new role in the true crime community as a spokesperson for the families and as somebody else who can explain to the families what's going on and what to expect. And so that was very encouraging. Um, I think it's unfortunate Lauren's whatever whatever people she lost when the truth came out about her, she seems to have regained all those followers. And I guess all I can say is that those out there who know her for what she is, just have to keep telling people that she's not somebody who can be trusted. So, and that's all I'm going to say about that. Y'all know it. I mean, I just think it it disturbs me that she's able to go out um, and mislead people when they're at their lowest point. I mean, it's it's unfortunate, and I'm glad that there are people like Kay out there who can say, "This was my experience, and I don't want you to get caught in that same trap." And that's not the only thing Kay has tremendous expertise at. I mean, she's been there, done that, and some. And she certainly would be somebody who would be immensely helpful to families that are going through it. So I hope that she's going to continue to do that. One of the cases that I really wanted to talk about and kind of dive into tonight is Kelsey Fitz Simmons. So, Kelsey Fitz Simmons, for those of you who may not know what this case is about, it is a case out of Massachusetts. And we continue to get these cases out of Massachusetts where law enforcement is questionable. The good old boy network is in full force. And there are some true concerns about some of the judges and their behaviors. So, um, so this is yet another one of these Massachusetts cases. Melanie Little has been covering it very closely. Defense Diaries have also been, Bob and Allie have been covering it as well. Um, so, for those of you who may not be familiar, Kelsey Fitzsimmons is 29. She was wanted to work in law enforcement. Originally she was a jail guard and then got on as a patrol officer in her local police department where she lived. Sorry. And she was engaged to a guy whose name is Justin Alayan. A lot of people are calling him Alien. And he's a fireman in the local fire department. So this all stemmed out of they had a baby together, and the baby was about 4 months old, and they were planning to get married last year in October. And so in June or July, they did a Jack and Jill bachelorette party. And so they all went away for the weekend, bunch of friends. And at this party, there was some sort of a disagreement between the two of them. And they wound up kind of leaving the party separately. And he then went and got a domestic violence restraining order against her. They were living in the home she owned. So they were sort of going through this rocky time. It was clear that the wedding wasn't going to happen. It was likely they were going to break up. And he'd been out of the house. He called her and asked her to come and meet him at a park with the baby. And he did that to distract her, and he didn't show up. Instead, he went down to the courthouse and got this restraining order. Now, restraining orders are always issued ex parte, meaning both parties are not there. And in general, that's a protection because you don't want your batterer to be there threatening you while you're in the courthouse trying to get a restraining order. So it generally is done to keep people safe. However, it also means that only one person is there to tell their side of the story, and the other person has to file for a hearing, and there has to be a hearing where the judge hears all the evidence. But initially, judges are going to err on the side of keeping people safe. So the next thing that happened was Kelsey was back at home, sitting on her couch with her 4-month-old baby, and knock, knock, knock on the door. She opens the door. Now, one other thing that you need to know, and that's that Kelsey had been struggling a bit with postpartum depression. She had gone to the doctor, gotten medication, was doing treatment, and had just been cleared to go back to work and be able to possess a firearm, and she'd just been cleared to go back to work as a patrol officer. So she knock, knock, knock on the door. She goes to the door, and here are 3 of the guys that she works with in the local police department. These are her colleagues, okay? And they say, "We're here to serve a restraining order." And the restraining order gives Alain, the father, custody of the baby. And so, but they let him come to take custody of the baby. So he stays downstairs and they say, "We need you to pack things for the baby." So she and one of the officers go upstairs to their loft bedroom. This it's important to know this is a loft, doesn't have a door. So they go up the stairs and she is putting together stuff for the baby. And this is where the 2 stories diverge. The police officer, Officer Noonan, says that she reached behind the door that doesn't exist and pulled out her gun and pointed it at him. Now, what Kelsey says is in that moment, as she was packing up her baby's things and her life was just flashing before her eyes. I mean, a restraining order meant that probably her career was going to be out the window, her work, she wouldn't be able to work, and most importantly, they were taking her 4-month-old baby. She was still breastfeeding to away from her, and she says that she pointed the gun at herself, um, and the officer says that she pointed it at him, he said no, and he fired point blank into her chest. She was airlifted in very, very grave condition. They saved her, but she was in the hospital for 53 days before she was released. While she was still in the hospital, they presented the case to the grand jury and tried to get a murder charge. The grand jury would not indict her for murder, but they did indict her for assault with a deadly weapon. So she, when she was released from jail, there was a female judge on the bench who was, excuse me, I had to sneeze. There was a female judge on the bench that was assigned to her case, and who absolutely from the beginning thought that she was responsible, and decided that she was going to put on Kelsey a lot of very onerous requirements in order for her to be on release. So she was released with not one, but two GPS units, one on her ankle and one in a scram monitor, which is an alcohol monitor that she had to blow into, has had to blow into several times a day, just on random. It gives her a signal and she has to blow into it. When she was first released from jail or from the hospital, she still was recovering from multiple um, very fractured ribs, liver damage, lung damage, and it was very painful for her to have to blow into this thing. So her attorney went back to the court and asked the court to relieve her of the obligation. And instead, the judge put her back in jail. She stayed in jail for another couple months before she finally was released. When they went back to the judge, was just before Christmas, and said she now is physically able to comply with the monitoring. By that time, they had filed a motion to recuse the judge. When they did the hearing on being able for her to be able to or not have to blow into the monitor, the judge was very insulting and very um, condescending, and it was very clear that she had no sympathy at all for Kelsey. So they filed a motion to recuse that judge. And interestingly enough, the chief judge said, well, she's rotating out of that assignment into civil court anyway, so it's kind of moot. But she did get a new judge. So I watched the hearing today on, they, was a little surprising they had a hearing, but some really important information came out of it, pretrial information. So, a week ago, they went back to this new judge who's now assigned to the case, and who I really like. I think he's really even-handed. They went back to him and asked him whether or not she could be relieved of the obligation of having to live with her parents. The house that she was living in with Elaine, she had to sell to pay her attorney fees. So, and the court allowed her to live with her parents. They said and there was a whole discussion about her parents were obligated to alert the parole and probation or alert the court if she was not following all the rules. So she's been under her parents' supervision since she was released from the hospital. The boyfriend, ex-boyfriend, still has the baby. The baby is almost a year old now. He still has the baby, and she has not been allowed to see the baby since the day she was shot. And the judge in the earlier judge, the one who's been booted, ordered her to have no contact whatsoever with the baby or through a third party, even remote contact, even video contact. She could have no contact at all with the baby, which is horrible. This baby's, I mean, in its most formative year, as far as parental bonding. So her attorneys went back to court last week and filed a motion with the judge asking that she be relieved of the obligation to live with her parents. She's still on the GPS ankle monitor, still blowing into the scram monitor, but she wanted to be able to move into her own place so that she could get into a position where she could have her child. And the judge agreed, and the judge removed that obligation for her to live with her family and allowed her to move into her own place. They had it all set up. So one of the things that they're concerned about is the family law case is coming up. I think the 14th of April is the date that that's going to be heard. And so if she is acquitted on this assault charge, well, to be honest, even if she's convicted of the assault charge, she's already served more jail time than the judge could sentence her to. So she is trying to get all of these obligations removed. Oh, and when the judge said she could move into her own place, the judge also lifted the order that said that she couldn't have contact with her child. And this judge said, as long as she was compliant with her parole, this judge would leave it up to um, Department of Human Services, to child welfare, because child welfare is involved. So those were two huge things that you could just see the relief on her face and when that happened. So she is set to start trial on the 23rd, so next week on Monday. And this is the trial on one count of assault with a dangerous or deadly weapon. So today there was a hearing, and there were a couple of motions that they wanted to wanted to have the court decide. But the biggest thing was, while they were there, they waived jury. So I want to talk a little bit about jury versus a bench trial. So what this means is that the judge is going to be the finder of fact, not a jury. And there are times, and I think this is probably one of them, when this is a good choice. So I want to remind you, last year, I think it was last year, maybe it was, no, I think it was last year. There was a woman, also Massachusetts, named Penny McGee. And the facts of that case were really interesting. Um, Husband and wife married and divorced. They have a really highly conflicted relationship. They've got a couple of kids. There's a lot of push back and forth about custody of the children. And the ex-husband is in very poor health. He's got a number of very serious medical issues, including a very serious heart condition. So she comes over one day and they get into an argument. It is strictly a verbal argument, but they're both angry at one another in the entryway of the house he's living in. There's a whole lot of other details that go into it, but it probably is not that important. But they have this argument, and he suddenly clutches his chest, keels over, and he's had a massive heart attack. She immediately calls 911. She's doing CPR. 911 shows up. She rushes to the hospital with him. Now remember, this is her ex-husband, but the father of her children, and he doesn't make it. And the state turned around and charged her with murder, claiming that it was her fault that they had this argument and that she should have known that an argument could have caused his death. And everybody was sort of outraged and thinking to themselves, there goes Massachusetts again. And this case was assigned to none other than Beverly Cannoni. She was the judge in the Karen Reed case that we all love to hate. Well, Penny McGee opted for a bench trial, and Judge Cannoni found her not guilty. So I think that there are some times when it is a good choice. For example, if you have a client who has a lengthy criminal history and you have the kind of case, say it's a self-defense case, where the only two people who really know what happened are the victim and the defendant. And you think that there's a good chance that your client could beat this if they testified. Well, you don't want them to testify in front of a jury because the prosecution is going to come along and they're going to haul out this person's abysmal criminal history. Now, a judge knows the law and a judge understands the process and is much more likely to say, I can put aside the fact that your client has a rap sheet the length of the Colorado River. I can put that aside and I can judge this person's credibility on what I see on the stand and what I'm presented with without jumping to the conclusion that because they have a really, really long rap sheet that um, they must be guilty now. It's not that easy with a jury. So I think that's one instance where I think it is it's helpful to have a judge make the decision. The other time is once again, if you think your client needs to testify and you don't want there to be a he said, she said sort of push and shove, because if it gets really emotional, a jury is not going to be as able to set aside the emotion of it. Um, and this is a very highly emotional case. Well, after the defense had had a couple of hearings with this new judge and had found him to be quite even-handed and quite fair, they decided that they're going to waive jury. And I think this is a really good decision for them because there's no question Kelsey is going to have to testify. She was the only other person in that room, and she is the only other person, she's the only person who can speak to what her mindset was at the moment that she picked up the gun. And that being said, I think it was an excellent choice for them to waive jury. So um, I I see a comment that says she needs mental health, not a jail cell, and her baby taken away. I agree completely. She was clearly suffering from postpartum depression and anxiety, um, and she she very proactively addressed that and had been cleared by mental health professionals to go back to work and carry a gun. So, she and everything I've heard is that she's continued to, do any sort of mental health treatment that's needed to help her deal with the trauma of what happened to her afterwards. Not just her baby being taken away from her, but being shot. So, um, that trial is going to start on the 23rd. Now, one of the kind of thorny issues is how do we tease out this is a perfect example of the reason why doing family law and criminal law together often is helpful because there are so many times that the lines blur, and this is a really good example. So, what comes in and what doesn't? Well, the judge has been really good about saying because Justin Alain has been making all sorts of representations in the press and all sorts of accusations about Kelsey. And the judge has been very pointed in saying this is about what happened in those 5 seconds at the top of the stairs upstairs. And it only has to do with Kelsey and Officer Noonan. This does not have anything to do really with Justin Alayan. So I am happy the judge is really going to keep the focus on that because Justin Alayan isn't the victim. I mean, arguably, if you're being accused of attempted assault with a deadly weapon, victim is the person who claims that you attempted to assault them, and that would be Officer Noonan. This has nothing to do with Justin Alayan. However, I'm sure that they're going to try and make it about him and about what led up to this confrontation. So I think that the judge is going to really lean into, let's not make this a litigation of child custody or of the restraining order. That is for a different court. So, first of all, I don't think this trial is going to take more than a couple days, particularly since it's in front of a judge. Because you don't have all those fits and starts. You don't have now the odd thing about a bench trial is that the judge is going to be also calling balls and strikes. The judge is going to be making the decision about objections. So, but the judge knows the rules of evidence, and the judge is going to be able to say, I can't consider that when I'm when I'm deliberating. I can't consider that. So I think the trial is going to go quicker because they don't have a lot of that there won't be the delays that happen in a jury trial. And I also think that they will streamline a lot of the testimony because this judge already knows a lot of stuff. You know, they're not going to have to explain the technical stuff to the judge because the judge knows it. So those are good things. Those are good things for Kelsey. And I think the trial is going to go fairly quickly. Now, the next thing that is kind of interesting is that the family law case, the hearing on custody, comes up right after the trial. So it's going to be I think it's the 14th of April. And in that trial, there's some important differences. First of all, in a criminal trial, as you all know, the legal standard is proof beyond a reasonable doubt. In a family law case, it is more likely than not, or 51%. So the evidence only has to tip 51% in favor of one or the other of them. So what's relevant for child custody? Well, in a child custody case, in every instance, the very first question the judge has to ask, these are never, family law cases are not decided by juries. The very first question the judge has to ask is what is in the best interest of this child? Is it in the best interest of this child that his mother be limited in contact with him? Is it in the best interest of this child that father has custody? Because actually what's happening is paternal grandmother has custody. That's another piece of it. Paternal grandmother is quite a piece of work. And in a lot of ways may have very much been in involved in fomenting this whole situation. So the questions are always going to be what's in the best interest of the child. So, um, if you want my prediction, I think that I think the judge is going to find her not guilty. I could be wrong, but I think there is some serious reasonable doubt about whether the prosecution was saying, well, she went upstairs and she's mad at Justin Alayan because he took this restraining order and he was going to take the baby. And so she went up there and she was angry. And so she took her anger out on her coworker. And the judge was like, excuse me? I mean, that you could tell that the judge was like, I'm not buying that. This is Justin Alan's not the victim, and this isn't about his relationship with her. So the prosecution's trying to get it in because it goes to motive, goes to bias, yada yada. But we already saw that the judge isn't necessarily buying it. So you could already see that the judge was kind of hitting the BS button when it came to some of the prosecution's arguments. Once again, there's this whole like rat's nest of who knows who and who's friendly with who. And it appears that Elaine had some friends in the police department. And yeah. Um, so there's a lot going on in this case. I have toyed with the idea of streaming it. Um, I'm still toying with the idea. Um, I do I do have a medical appointment one of those days, but I think if y'all are a little bit flexible, maybe we could do it. Um, I I haven't streamed things before, but I feel like this is a case that is kind of ripe for commentary and explanation, especially when it comes to the judge saying, "I'm not gonna consider that. You can take that up with the custody in the custody case." So, I'm kinda thinking about it. Let me know what you think. Um, because it's not gonna be a super long trial, so I wouldn't be, streaming it for days and days and days, and I would probably do more like what some of the other law, uh, tubers do in that I would stop and do explanations and commentary as it went along. And some people like that. Some people just want to sit and watch the trial end to end. So, but let me know what you think. Um, but I am really interested in the child custody case. They're generally not made public. Their juvenile cases are generally considered not open to the public. So I would be highly doubtful if we have too many insights into that. But I really think that the criminal case could give us some big insights into what might happen in that case. So, I mean, really at this point, regardless of whether she is found guilty or not guilty, she's already served more time than she would be sentenced to if she was found guilty. So I think this is, I know that she would very much like to be found not guilty and be able to return to her work. One of the things she said when uh, today, I think, when they asked, the press was talking. Oh no, she said it in court actually. She was the judge had her get on the stand and they did the whole colloquy on, do you understand your rights and everything that you're giving up if you waive jury? And while they were talking about that, he asked her about her education. And she said, I have a bachelor's degree and I went to law school for 2 years. And or maybe she said I have 2 more years. I can't remember. But he's made some comment about it, and she said, "Oh, I plan to go back." And I thought, "Go, Kelsey." Nobody in the world would be a better advocate than somebody who has been through this. So I was happy to hear that she's contemplating law school. We also heard that Corey Richens got her MBA while she was in jail. And she, the walk the dog letter was allegedly found in a study guide for the LSAT, which is the entry exam for law school. So she could be kind of doing online law school like Kim Kardashian. We haven't heard much about that lately. She struggled to pass the baby bar, so maybe that ship has sailed. But I was excited to hear that. So we're going to stay right on top of that one. That one's really interesting, and I'm sort of seeing a few comments saying that you might be interested if I decided to stream that one. So I'll give it a thought. There were a couple of other cases that had some date changes, so I wanted to just talk about those really briefly, just what was going on and why the dates were changed. Um, Lindsay Shiver, this is a case out of the Bahamas, and we've been hearing all along that she was going to go to trial in March. She was going to go to trial in March, and it's maddening because the Bahamas, it's I mean, folks, in a lot of ways, it's still a third world country. So it's tough to get information out of them. But I did discover that it has been continued yet again, and it is now set for trial on June 3rd. Because we kept hearing it March 2nd, we're going to trial, and then it didn't happen. Um, so hopefully that one will finally get to trial. Aaron Spencer. Aaron Spencer is the guy from uh, Arkansas, Arkansas, whose daughter was kidnapped, was SA'd. The guy was identified, arrested for kidnapping and grape, and was out on bond when Aaron Spencer woke up because the dog was barking, and he realized that his daughter was missing from her room. This guy had once again taken their daughter. He then followed. He had Find My Phone on for his daughter's phone, and he followed them. He did alert the police, but they didn't show up in time, and so he followed them, kind of ran the guy off the road, confronted him. The guy originally, his daughter kept trying to get out of the car, and the guy kept pushing her back in and trying to keep her in the car. Then the alleged victim, the kidnapper, Michael Fossler, got out of his car, and Aaron Spencer claims that he charged him, and Aaron Spencer shot him. There are two different doctrines that come up. First of all, it there obviously it's self-defense if you're defending against somebody who's the aggressor. But there also is a legal doctrine of defense of others. So if you are defending someone who is helpless, that also is an affirmative defense like self-defense. So um, he was he was scheduled for trial. It's been scheduled for trial a couple of different times. One, they couldn't do it because there was a snowstorm in January, and then I think in February he was scheduled for trial. They filed a motion to recuse the judge because the judge appeared to be very biased, and the judge had absolutely forbidden any media coverage of the case. I mean, it was more locked down than Delphi. And they filed a motion. It went all the way to the Supreme Court, and the Supreme Court said, "You're out of here," to the judge who had been so biased, replaced with a judge that once again seems to be fair and reasonable, the same as we had with Kelsey Fitz Simmons. And so they had a hearing today, and they set a new trial date. The first thing that happened was they said, you know, if we have to disqualify the judge, you can't go to trial in February. We're going to have to set it out. So they had not yet set a new trial date until today, and that was set for June 22nd. He is charged with second-degree murder. There are a lot of people online who are commenting on the fact that there is a great deal of corruption in this county and a great deal of quid pro quo. You scratch my back, I'll scratch yours. Particularly among law enforcement, lawyers, judges. So there's a lot of suspicion about whether or not Aaron Spencer can get a fair trial. In the meantime, Aaron Spencer decided to run for sheriff, and he got a resounding win in the primaries. So he will be in the fall election running for sheriff against the incumbent, who he got more votes than in the primary. So because he's intent on cleaning up the mess, so he says. So we'll see what happens. But I think there's a good chance that he may be acquitted because of the self-defense and defense of others argument. So, and lastly, I wanted to talk about Tyler Robinson. This is the guy who is accused of shooting Charlie Kirk in Utah. The media or his lawyers tried really hard to keep cameras out, particularly at the next hearing. It appears that the next hearing is going to deal with some evidentiary issues as well as perhaps um, sort of like a rebuttal motion, sort of. I'm not quite sure in Utah how that works, but the prosecution wanted that hearing closed, and the court denied that. So it will be open and being streamed, and that next hearing is on the 17th of April. So we'll keep an eye out for that one. I wanted to put it on my calendar list, so we'll keep an eye out for that one because it may have some meaty evidentiary issues that could really cast some additional light on the case. So those were the things that I had that I wanted to talk about, the individual cases. Next month in April, we have Courtney Clenny coming up, Tracy Grist, that is the mother in the Ristelli case. Aaron Spencer has a pretrial. Jennifer Gledhill has a pretrial, and then Tyler Robinson. So, and then Tyler Robinson has a preliminary hearing in May. Now, preliminary hearings, they could go to the grand jury and get an indictment and not do a preliminary hearing. We've seen that happen before. Definitely happened in Coburger, happened partially in Vallow Daybell. Chad Daybell had a preliminary hearing, and after that, Lori waived her right to a preliminary hearing. So, so those are all the things I wanted to chat about. What are you chatting about? Oh, Hellis says Andrea Burkhart is covering Robinson, and she always does a great job. So definitely want to keep an eye on her, what she's doing. So what kind of questions you got for me, y'all? Yay! We love Andrea. I'm not sure I know. It came up during the pretrial, and it's not something that I was familiar, but it sounded to me like they were saying, we're going to put on some of our defense evidence, or we're going to try and get rulings on our defense evidence, and we don't want the public to know about what we're putting out there. So, a lot of times the defense will say, well, we want an evidentiary hearing that's sealed or closed. We saw a lot of sealed documents in the Richens case. Um, because we don't want to let out our trial strategy while we're trying to get these evidentiary rulings. So I think that's basically what they were saying, but it wasn't super clear why they wanted the hearing closed. But that's what it sounded like to me. They were sort of saying we don't want our we don't want to show all our cards until we're ready for trial, and so that would be one way of not doing that. And they don't want the information out because they're afraid that it's going to impact the jury pool. So, yep. Uh, so I think that's what they were trying to say, but the judge didn't buy it. He just said trials are public. Um, and he was pretty adamant about it. So, good questions. Hi, Polly. Bringing up Mark Means reminds me of whatever happened to Judge Boyce and his sealed documents. Oh, I haven't given up on that yet. Um, I'm definitely going to file a motion and ask for them to be unsealed, and I think he's going to be hard pressed. I mean, I know what he's going to say. He's going to say, "I won't release it until all the appeals are exhausted," but I don't know that that'll fly. But I'm gonna keep pressing for him because I want to know what was in those motions having to do with the prosecutor. Um, Because I think there was some misconduct, and I think Judge Boyce just didn't address it and kind of buried it. So, what else you got for me? Hi, HMS Gen X lady. That sounds like a boat. What was the part about Corey's mom needing an attorney if she testified? Could that be why they didn't put witnesses on? Am I understanding that correctly? You are understanding that correctly. The defense asked the court to appoint an attorney for Corey's mom. So there were a couple reasons why. First of all, um, they were alleging that Corey was attempting to tamper with witnesses. Now, the reason why they didn't charge Corey with witness tampering was because they couldn't prove that letter had been delivered. However, not too long, sorry, I'm so antsy tonight. Um, Not too long after that letter was discovered, there was also an instance where Corey held a letter up to the glass while she was meeting with her mother. And that letter was never found, so they were never sure what that said. But shortly after the walk the dog letter was found, Corey's mother did an interview where she just regurgitated everything that had been in the walk the dog letter. So there was some discussion about whether or not Corey's mother had been attempting witness tampering because she was relaying the information to Corey's brother, Ronnie. Um, and there was some discussion about whether or not there would be criminal liability and whether or not there would be a chance that she could incriminate herself. So they definitely wanted her to have legal advice before she was before she gave statements that could be incriminating. So that was the primary reason why they were asking for her um, to get legal advice before she talked to the police. The other reason was because, sometime in the past, Corey's mother had been in a long-term relationship with another woman, and that woman died, under kind of suspicious circumstances and left everything to Corey's mom. So, there was some suggestion that maybe the Corey was copycatting her mother. And, I think if law enforcement was going to ask her about that, she probably needed an attorney as well. So, what else you got? Hello. What does one have to do to get approved for press credentials? Well, that really varies from judge to judge, from court to court. There are some judges, um, like they did in the Vallow Daybell trial, that said we're not going to make any provisions for press. It is first come, first served. If the press wants to be here early and stand in line, then they'll be guaranteed they get seats. But we're not going to set aside a particular area for the press. In other cases, they only allow mainstream media. In some cases, they're more liberal and they allow anybody who claims to be press. So it really is up to the discretion of each individual court. Now, some courts have a policy. They already have guidelines for who is considered press and who's not. But it really depends on the individual courthouse and often the individual judge. So, good question. Um, I know that in the Richens case, the court, the people who were involved in the press applied to the court for credentials, and the court gave out wristbands that allowed them front the access to the press row. And I think that varied from day to day, but the day of closing arguments, Gigi and Lauren both ended up on the press bench, and Nate Eaton didn't get in. So, certainly Gigi is affiliated with Law and Crime and probably should have press credentials. But, I don't know why Nate didn't get in because he's clearly, a reporter with a news organization. East Idaho News is an established news organization. So, um, it can be a little bit capricious, depending on the judge. Any other questions? Can Corey see her kids? Hi, Polly. Uh, I heard chatter about losing her parental rights. So this is a good question. It depends upon the state and their rules. In the state of Oregon, a parent who kills the child's other parent, there is a rebuttable presumption that they're an unfit parent. Hopefully that makes sense. Um, the law presumes that if a parent kills their child's other parent, they're presumed to be an unfit parent. That presumption can be rebutted by something like self-defense. So it's not a carved in stone finding, but it does lean in that direction. So with Corey being sentenced, we know that the murder charge carries life without parole. So with Corey being sentenced to life without parole and Eric being dead, it's up to the two families as to who steps up. My understanding is that the children have been living with Eric's family, with one of his sisters, since Corey was arrested, and that is intended to continue. It is going to be up to the family to determine whether they're going to press the issue of her rights being terminated. Because typically rights terminations can only be done by the state. Um, and if the family says, "Look, we don't really need to terminate her rights. She's clearly going to be in prison for the rest of her life. We can have guardianship over the children. That means we make all of the major decisions for the children. Corey won't really have any decision-making power, and with that we'll make a decision as to whether or not the children see her." Then at least the door is open, because then you have to remember that it's not about Corey. Um, when the family court is looking at custody and parenting time, those things have to be looked at as to what's in the best interest of the child, and parenting time or visitation is for the benefit of the child. So a judge is not going to care what whether it's punishment to Corey, or whether or not Corey's can see the children in prison. The judge is going to look firmly at what's in the best interest of these boys. Is it in their best interest for them to continue to have a relationship with their parent? That may take the recommendation and study of a psychologist saying, "Look, I've assessed these kids, and I've assessed the situation, and based on my education and my understanding and my assessment of the children, I think it's in their best interest that they maintain a relationship with their mother. It's going to be less harmful for them to have a somewhat superficial relationship with her and know where she is and be able to see her. Um, it's less damaging to them. Um, but it's definitely not going to be one of those, "Oh, Corey deserves to see her kids." It will strictly be decided based on the best interests of the kids. So, that's a good question. Every time we run into one of these cases where you've got young children and one spouse kills the other, they've basically been deprived of both their parents. And you really have to sort of focus in on what's going to be in their best interest. So, does it mean that maybe Corey gets to see her kids occasionally? Yeah, maybe. And does that seem like, oh, she shouldn't be able to see her kids? Well, maybe. But the bigger question is, what is going to be best for those kiddos? So, good questions. Hello, Hella. I find it interesting how people like Sky now. If she were actually representing Corey, still not so much. I completely agree. I watched some of the pretrial hearings that Sky uh, was in. Now, she's stunning. She's wicked smacked, to quote the East Coasters. She is a really good lawyer, but she's a defense lawyer. So she's going to be, I always remind people, sometimes criminal defense lawyers have to make arguments that they stand around and think, "Oh, can I make that argument in court with a straight face? Can I make that argument in court without putting a bag on my head?" I mean, we used to have a joke around my office. It was like, "Yeah, well, today's the day you get the office bag. You get to go to court and put a bag over your head, and suck it up and make a dumbass argument because it's all you got." And you gotta make the argument for the record, even though you know that there's not an ice cube's chance in hell that that motion's gonna go anywhere. You still have to do it because due process has to be served. So I totally agree. I think that a lot of people probably would have found Sky um, as abrasive. I think a lot of people would have found Skye a lot more abrasive and confrontational than either of the two public defense lawyers, Nestor or Lewis, were. Yes, there were times that they pushed back, but I did not find in any of what I watched, and I watched almost all the trial, I did not find any instance where either one of them were particularly what I would consider out of line. Now, I think Kathy Nestor was a little too casual sometimes and a little bit too off the cuff, more so than I would have been. But on the other hand, that's her style, and it worked. Um, so I didn't find either one of them lacking. They certainly were not Donna Adelson's funeral home lawyer. Um, I thought she did a terrible job, but did not think one of these lawyers did a terrible job. And I do think you're right. I think that had Skye stayed on, um, a lot of people would have said, "Whoa, she's abrasive, or she's bitchy," or and I want to remind you, um, we still live in a world where women and men are perceived differently. So a man who goes into court and he hits really hard and he presses on, boy, he's a really assertive lawyer and he's really doing good for his client. Women always face the criticism of, oh God, she's just so bitchy, or she's shrill, or she's I understand that people were put off by the demeanor of the two defense lawyers, but let's remember that they're living in that world where people are still judging them based on the fact that they're female. People are still looking at what they wear to court rather than saying, oh, he's in a dark suit, she's in a dark suit. Oh, good. They're still looking at them, still assessing them and saying, well, that was a fashion choice. Uh, you know, the bow at the neck was a fashion choice. But they don't say the same thing about somebody's necktie. So remember that there's always a little bit of an uphill slog for women lawyers. And yeah, Jackie Fulford, attorney at law and funeral home proprietor. Yeah. I mean, she did a terrible job for Donna Adelson. Um, Maybe she didn't have that much to work with, and Donna wasn't that easy a client, but still, we have to remember that they were there to do their job, and I think they did their job. Did they make some arguments that I might not have made? Yeah, but they had a plan, and they stuck to the plan. Um, I thought their closing argument was terrible. I mean, putting up statues of weeping angels? I don't think so. I thought they could have done a much better job at their closing. But I also had a lot of sympathy for him because she got up there and she was sick as a dog. They were both really sick. I mean, you could just tell as she was standing up there that she was doing everything she could to hold her shit together because she was sick. So she powered through it. And, I'm sure that she walked away and thought, man, I did not leave it all on the field for that one. Because she just didn't have it. And, you know, the the facts weren't great on their side. So, um, you know, attorneys are human, and they they put their heart and soul into their cases, and they put their heart and soul into their clients. We all go and do our best. At the end of the day, we're human beings, and we make mistakes, and we're standing there in the breach. At that moment, we have 199 things going through our mind. We're thinking about the next witness and whether that witness is here and whether they're in the hall and whether or not they're going to show up. We think about the about the questions that we've got, and we need to cover all these things. And we've got the other side objecting, and we've got to think on our feet about overcoming that objection. And and we've got to know the rules of evidence, and we've got to be able to pull it up in in the evidence code if it gets to that. And it's the lawyer who is at trial has so many things running through their mind, and they are multitasking in the moment. You layer on top of that high publicity, high stakes, and it is, uh, and it is, it's a lot. And I'm here to tell you, you do a week-long trial, it's exhausting. You're up burning the midnight oil every night, trying to prep your witnesses for the next day, trying to prep your cross for the next day. And by the time you're done with that trial, you are so tired. I mean, you just drag in and think, it's gonna take me days to get my energy back from this. I've just put everything into it, and if you layer on top of that that you're sick, that sucks. I mean, it does. So, yes, Hella, you can clip, getting the office bag today. The other really funny thing is when I, when I first started doing public defense, I worked for a consortium of sole practitioners who had a contract with the state to do public defense. So they recruited me to come on board, and they were in the process of changing their corporate structure. And so I practiced in Bend, Oregon. And, of course, you deal with court staff all the time, and they're busy doing paperwork, and the judge is doing paperwork, and you're doing arraignments, and they're just like one after another. And so they called all of our organizations by some moniker, some little shorthand. So forever, we had always been the initials of the county defenders. And so when they changed the corporate structure, they changed it to Bend Attorney Group, which sounded fine, except I was the only woman. And so when I was standing up in court and I was picking up arraignments that day, and the judge who was on the bench was a great guy, great judge, had been a general in the National Guard, and he was a really great guy. And I'd known him for a long time. And so I standing up there accepting um, arraignments, and the judge, and he prided himself on being on top of who was in what organization and what they were called, and all those things. He was always on top of things. So he's going along, and he says, um, and I'll appoint the bag. And then he looks up at me and his eyes get really big because he realizes he just called me a bag. He was like, the Ben's Attorney Group, I'll appoint the Ben's Attorney. He was so put off. He actually called me into his chambers and apologized, and I just laughed at him and said, that's one of the tamest things I've been called recently. But so I was the bag. And when you had to go to court and make an argument that you couldn't keep a straight face for, if you put the bag over your head, you could do it. So yeah. Uh, so what else you got for me, Jen? Last questions, and then we'll wrap up for the day. Hi, Tiff. Why didn't they bring with them someone who knows how to keep the peace, someone for the baby? Okay, well, first of all, they had 3 police officers, so you would think that they would be able to keep the peace and diffuse the situation. They did a shitty job of that, as you might think. There isn't really a mechanism to have someone, say from child welfare, stand by on one of these civil standbys, because the baby is passing from one parent to another pursuant to a court order, and the state isn't involved in determining where the custody of the baby goes. Let's remember that when the state gets involved, they take wardship over the baby. So they step into the shoes of the parents legally and the baby becomes a ward of the state. But that doesn't happen in one of these. This is strictly an order between these two parties. So the power of the state, the judge is saying, you two need to stay apart and you two need not to have any contact with one another. And this parent needs to have the baby. And that is how we will keep everyone safe until we can have a hearing on this. And that's what happened. So the police should have diffused the situation. Instead, they let Elaine come to the property to get the baby. And I'm sure that that was not really a healthy thing. And I think it was his mother was with him. Um, I'm not 100% positive. I know there was another person there, and but I don't think that person was particularly helpful in transferring the baby. But honestly, the police should have been I mean, it's their job to kind of diffuse these situations, so they should have been able to do it. I did see that quite a um, there were quite a few recordings that came out of that day of him calling the police and railing at them for not doing a standby there, and so um, yeah, I mean, it kind of showed his temperament. Now, Kelsey Fitzsimmons, in the family law case, filed an affidavit um, in her defense. Um, oh, dang it, you gotta go teach shortly, Hella. We're having way too much fun with you too. I'm sure your students will appreciate getting their teacher there, though. I thought you said you had to go to the beach, and I was about yeah ready to lose myself on you because there's no way it's beach day here. Although we did have a nice day today, and it was warmer than usual, but we're just barely edging into spring. Um, so to get back to it, Kelsey filed an affidavit in the family case in which she outlined that Justin Alain has a pretty substantial drug problem and alcohol problem. And her side of what happened at the bachelorette party is very different. But remember, she never had an opportunity to challenge the restraining order because she was shot that day and 53 days later, when she got out of the hospital, she had already been indicted for attempted assault. And so at that point, they entered into an agreement for him to have temporary custody of the baby. She was in and out of jail. I mean, there was a lot of uncertainty. So, so I, I hope that we're going to get a good outcome for her. So 90 where you are, Tiff, huh? Do we know if the baby has a guardian ad litem? We don't know, and that really depends on the state. Um, some states require or may appoint an attorney for the child. I used to represent kids in family law cases pretty often. Either way, it's a good idea to have somebody who's advocating for the best interests of the child. Now, in a foster care case, a state case where the child is a ward of the state, there is a great national organization called Court Appointed Special Advocates, CASA. And they are people who go to court and whose only job is to advocate for the child who is being a ward of the state. But there isn't a sort of a family law equivalent of that. Um, so uh, the best that we can do is to have an attorney appointed for the child or a guardian ad litem. Sometimes the GAL is an attorney. It depends on the state. So, but it's not a bad idea to have somebody appointed for the child. So good questions. Good questions tonight, guys. Um, Hi, Lauren. Lauren J, 7628. Would the fact that Corey's attorneys didn't put on a defense impact her appeal in any way? Absolutely not. She is not required to put on a defense. The burden rests with the state to prove beyond a reasonable doubt that she committed the crime. And it is more likely, it is more typical for the defense to rest without putting on a case, particularly in a case where really the only witness is the defendant. So not unusual at all, and it absolutely will make will have no impact on an appeal, because the Supreme Court is required to recognize that the state has the burden. So the things that get appealed are the court's rulings on motions and those sorts of pretrial rulings on evidence. So those sorts of things are the things that get ruled on, and those don't require the defense to do anything except stand up and object, which they were doing a lot and making their record. I know at times people got annoyed with Kathy Nestor saying same objection, renewing our objection, but that was out of an abundance of caution. And the judge in this case was quite cautious too. So, so last question here. Do you think that Corey will appeal because of ineffective counsel? They always appeal for ineffective counsel, but we've talked about this before. Ineffective counsel, in order to make a showing that you had ineffective assistance of counsel, you have to be able to make a very good argument that but for your attorney's ineffectiveness, you would have won. There would have been a different outcome. So in Corey's case, she is going to have to be, her argument is going to be, but for the poor showing of my attorneys, I would have been found innocent or not guilty. I would have been acquitted. I think that is a really tough haul because there was a lot of evidence that came in against Corey. So I think it would be very, very difficult for anyone to make the argument that if only her attorneys had been better at their jobs, that she would have won her case. So, yeah, I think that's going to be a tough haul. They always argue it. So, um, so hi, Jacqueline. You turned 65 today. Happy birthday. You're a puppy. Spending the evening with Lori and friends is a lovely ending to my special day. Well, happy, happy birthday. You just a baby. And I just want to thank everybody for being here tonight. Thank you so much for all your support. You're always so wonderful. You're good to one another in the chat, and I appreciate that. But you're good to me, and I appreciate that more than you know. So, and as usual, I appreciate more than you know our great moderator, Jen. Couldn't do it without her. So thank you, Jen. And I am going to say good night. I will be back next Wednesday for more True Crime Wednesday. I'm going to take a serious look at whether or not you watch. If you are not subscribed, now is an excellent time to do it and get notifications, because there's a better than 50-50 chance that I'm going to do some live streaming of the Fitzsimmons trial. So if you want to do that with me, definitely get your notifications, and we'll let you know as quickly as we can. So I'm going to say good night. Have a wonderful evening. Thank you all so much for your kind remarks, your support, and I appreciate all of it. So I will see you next week. Well, I might even see you on Monday. See ya.